He accumulated 11 complaints within 36 months, all stemming from stops where he had presumed criminal intent based on outward appearance rather than concrete evidence. One Thursday evening in downtown Portland, Keir made a decision that would ultimately cost the city $2,700,000 and permanently conclude his career in law enforcement. A 34-year-old legal professional, David Richardson, was attempting to unlock the door to his own legal office, specifically Suite 431, on the 4th floor of a downtown building, having realized he had left his identification badge inside. There was no crime, no forced entry, and no initial complaint, simply a lawyer working late, engaging in an activity that thousands of professionals undertake every night in office buildings across America. However, Officer Keir perceived the situation entirely differently. He observed a black man in professional attire positioned at an office door after regular business hours, and his inherent biases convinced him that illicit activity was unfolding. This unfounded assumption initiated an unlawful detainment, a wrongful apprehension, and repercussions that would expose a pervasive failure within the entire department to address racial profiling. Before we continue our narrative, kindly inform us of your location. If this is your inaugural visit to our channel, please consider subscribing. Narratives such as this are vital to disseminate, and your support assists us in bringing more truth to light. Downtown Portland, Oregon. The Pearl District, a locale where burgeoning technology firms share accommodations with legal practices and consulting agencies. Modern office structures with expansive glass facades reflect the city's illuminations. It is the kind of environment where dedicated professionals labor until midnight, striving to meet pressing deadlines. It is a place where security personnel recognize regular occupants by their names and where no one gives a second thought to an individual entering an office at 10 o'clock at night. The time was 22:41 on a Thursday evening in July. The summer sun had descended hours prior. The building's corridors were tranquil, yet not deserted. A gentle hum emanated from the overhead fluorescent lighting. The elevator occasionally chimed as other late-working individuals arrived and departed. It was an atmosphere of normalcy, safety, and routine. David Richardson had dedicated 9 years to serving as a public defender, 9 years advocating for clients who lacked the financial means for private legal representation, 9 years fighting for individuals whom the justice system had already deemed culpable, 9 years spent within courtrooms, meticulously negotiating plea agreements, preparing for trials, and scrutinizing evidence until his eyes ached. His colleagues lauded him for his tenacity. His clients regarded him as a savior. Judges respected his thorough preparation. Prosecutors were well aware that he would not yield. He had earned his degree from Lewis and Clark Law School with academic distinction. He had served as a clerk for a federal judge. He possessed the capability to secure a corporate position that would yield 3 times his salary as a public defender. However, this was not the impetus behind his pursuit of legal education. When he was 16 years old, he had witnessed his own uncle being unjustly prosecuted and convicted. An overburdened public defender, a coerced confession, and a 15-year sentence for a transgression he did not commit. That formative experience had profoundly shaped his trajectory. Consequently, David elected to pursue a career in public service. He opted to represent those most in need of legal advocacy, and 2 years prior, he had established his own practice, focusing on criminal defense cases on a flexible fee basis, undertaking matters that other attorneys found unprofitable. His office occupied Suite 431 in a mid-rise building situated on Northwest 10th Avenue. It was a modest space comprising a single room, a desk, 2 chairs for clients, and filing cabinets densely packed with case documents. His law degree was prominently displayed on the wall adjacent to his certificate of bar admission. While not ostentatious, it was unequivocally his domain. That particular evening, he had been diligently working on a motion to suppress evidence for a client whose Fourth Amendment rights had been infringed during a traffic stop. The irony of the situation would not escape him at a later juncture. He had continued his work until his visual acuity diminished. Shortly after 22:30, he packed his laptop into his messenger bag, donned his suit jacket, and proceeded to the elevator. He was attired in charcoal gray trousers, a crisp white dress shirt with the sleeves casually rolled up, and polished black leather shoes. His messenger bag rested across his shoulder. He presented precisely as he was, a professional concluding a demanding day at the office. He reached the elevator, pressed the call button, and waited, only to then realize his employee identification badge remained on his desk. He required it to gain access to the parking garage. Without it, he would be unable to retrieve his vehicle. Therefore, he retraced his steps and walked back down the corridor to Suite 431. He retrieved his keys, selected the appropriate one for his office, inserted it into the lock, a completely ordinary, entirely lawful, and thoroughly innocent action. However, Officer Jason Keir did not perceive it in this light. Officer Keir had been assigned to patrol duties in the downtown sector that evening. His shift commenced at 2200. His responsibilities were to monitor the bar district, assess business closures, and respond to noise disturbances, standard procedure for a Thursday night patrol. Yet Keir had a propensity for entering office buildings uninvited. He would patrol parking garages, traverse hallways, and test door handles. In his own estimation, he was acting proactively, preventing potential crimes before they occurred, apprehending burglars before they could abscond with anything. His supervisors had never instructed him to cease this behavior. In fact, they had commended his initiative. Keir had made 6 arrests for trespassing during his 3 years on the force. It mattered little that 4 of these apprehensions had been dismissed because the detained individuals were, in fact, employees of those establishments. It also mattered little that the other 2 resulted in formal complaints regarding excessive force. The department had counted them as successes: proactive policing, crime prevention. That evening, Keir had entered the building on Northwest 10th Avenue without receiving any dispatch call for service. There was no activated alarm, no reported disturbance, no apparent cause. He simply entered through the unlocked main entrance and proceeded to the 4th floor via the elevator. Upon exiting into the hallway, he immediately observed David Richardson standing at the door of Suite 431, key in hand, in the act of unlocking his own office. In that precise instant, Officer Jason Keir's preconceptions took command. He saw a black man in professional attire at an office door after hours. In Keir's mind, this could only signify one thing. This was not a professional concluding a late workday. This was a burglar in disguise, someone intent on breaking into an office to pilfer computers, documents, or valuables. Keir did not consider that the man possessed a key. He did not consider that the man was dressed professionally. He did not consider the possibility of a completely innocent explanation. He acted solely on his ingrained assumptions. Do you believe that law enforcement officers should be permitted to enter private premises without demonstrable cause? Please share your perspective in the comments below. Officer Keir rapidly advanced down the hallway towards David, his hand instinctively moving towards his service weapon, his voice projecting with authority. "Sir, step away from that door." The command resonated through the quiet corridor. David turned in surprise. He noted the uniform, the badge, and the aggressive stance. He had experienced similar encounters before, not frequently, but enough to understand the potential for things to go awry. "Good evening, officer," David stated calmly, ensuring his hands were visible, the key still within the lock. "How may I assist you? Are you investigating forced entry?" Keir's tone was accusatory and confrontational. David blinked. "Forced entry? I'm in the process of unlocking my office. I am employed here." Keir, stepping closer, continued, "That is suspicious. I require identification." David felt the familiar burden of frustration begin to settle. It is inside on my desk. That is why I am opening the door. I forgot it when I momentarily departed." Keir's gaze narrowed. "Do not make any sudden movements yet." And there it was, the precise moment when an entirely innocuous action was being criminalized. David Richardson, a licensed attorney, standing at his own office entrance with his own key, was being treated as a suspect solely because Officer Keir could not fathom that a black man might rightfully belong there. "So, I am prevented from opening the door," David articulated, his voice steady, but tinged with restrained anger. "And I am unable to demonstrate my employment here. I simply require your cooperation," Keir responded, as if that explained the entire situation. David looked directly into the body camera affixed to Keir's chest. "You are receiving it," he stated quietly, "from the public defender assigned to this establishment." That statement should have given Keir pause. It should have prompted him to reconsider, to recognize the possibility that he might be mistaken. However, it did not. Because in Keir's worldview, individuals engaged in criminal activity would invariably present themselves in various professional guises: lawyers, doctors, business proprietors. He perceived it as a tactic to evade accountability. This is the juncture where bias transforms into danger. Officer Keir had already formed his definitive conclusion about the individual before him. A black man situated at an office door after hours was not a professional concluding a late work session. It was, in his mind, a crime in progress, and no amount of explanation would alter his conviction. "I need you to step away from the door and place your hands where I can see them," Keir commanded, his hand now resting on the grip of his service weapon. David's jaw tightened perceptibly. He had dedicated 9 years in courtrooms, arguing against unlawful stops, unreasonable searches, and violations of fundamental constitutional rights, and now he was experiencing it firsthand. "Officer," David inquired, maintaining a controlled tone, "my name is David Richardson. I am an attorney. This is my office, Suite 431. My name is clearly displayed on the door. My professional license is on my desk inside. I possess a key because this practice belongs to me. You are detaining me without probable cause." Keir advanced further. "I am investigating suspicious activity." "What suspicious activity?" David's voice escalated, his frustration manifesting. "I am unlocking a door with a key. That is not suspicious. That is commonplace at this hour in an office building." "Indeed," David asserted emphatically. "Attorneys frequently work late. That is our profession. Observe the door. The signage clearly reads, 'David Richardson, Attorney at Law.' That represents me." Keir briefly glanced at the modest plaque affixed to the door. "Suite 431, David Richardson's office." However, instead of retracting his stance or offering an apology for the apparent misunderstanding, Keir intensified his actions. "I still need to verify your identity." "Then permit me to open the door so I can present my identification," David countered, his patience rapidly diminishing. "No, you will not enter until I can confirm your right to be present." "This is preposterous," David exclaimed, shaking his head. "You are detaining me for entering my own office." "Turn around and place your hands behind your back," Keir ordered. David's eyes widened in disbelief. "You are arresting me." "I am detaining you pending verification." "Verification of what?" "I have informed you of my identity. I have stated that this is my office. I possess a key. What further verification is necessary?" Keir reached for his handcuffs. "Turn around." And at that critical juncture, David Richardson, a public defender who had devoted his entire professional life to combating precisely this type of governmental overreach, faced a critical decision. Should he comply with an unlawful detainment and allow the system to perpetrate an injustice against him, or should he resist, risking an escalation of the situation? He chose to comply, acutely aware of the dire consequences that befell black men who opted otherwise. Should legal professionals be exempt from unwarranted stops within their own places of work? Please share your opinions. David slowly turned, raising his hands. "I am complying under protest," he stated clearly, ensuring his words were captured by the body camera. "This constitutes an unlawful detainment. I am an attorney entering my own office. You possess neither probable cause nor reasonable suspicion, and I intend to file a formal complaint the moment you release me." Keir maneuvered David's arms behind his back and snapped the handcuffs shut. The cold metal bit into David's wrist. The indignity of the situation inflicted a wound far deeper than any physical discomfort. This, he realized, was the tangible manifestation of racial profiling empowered by a badge. A black attorney, within his own building, at his own office, with his own key, being subjected to handcuffs because an officer could not conceive of his legitimate presence. A door creaked open further down the hallway. Another legal professional, Sarah Chen, who occupied a suite 2 doors down, emerged. She had overheard the raised voices. "David," she called out, her tone conveying confusion. "What is transpiring?" David turned his head in her direction. "Sarah, I am being apprehended for attempting to enter my own office." Sarah hurried towards them. "Officer, that is David Richardson. He is a public defender. That is his office. He works here every day." Keir barely acknowledged her presence. "Ma'am, please step back. This is a police matter." "Police business?" Sarah's voice rose in disbelief. "He has been in that office for 2 years. I have collaborated with him on cases. This is utterly unreasonable." "Ma'am, I will not repeat myself. Step back." Sarah retrieved her mobile device and commenced recording. "I am contacting building security and the Bar Association. This constitutes harassment." Keir radioed for backup. "Dispatch. This is Unit 15. I require an additional unit at 1040 Northwest 10th Avenue, 4th floor. Potential trespassing arrest. I also have an uncooperative witness on scene." Within moments, a second patrol car arrived. Officer Linda Torres emerged from the elevator. She had been with the department for 12 years. She had previously worked with Keir and had learned to question his judgment. "What is the situation?" Torres inquired. Keir gestured towards David, who was still cuffed. "I apprehended this individual attempting to illegally enter an office. He claims employment but lacks identification." Torres observed David, then the door, and finally the prominent signage clearly identifying it as David Richardson's office. "Kemper," she stated quietly. "His name is on the door." "It could be a coincidence, or he might be using a stolen key," Keir offered defensively. Torres approached Sarah, who was still recording. "Do you know this gentleman?" "Yes," Sarah replied immediately. "That is David Richardson. He is an attorney. This is his office. He is here almost every night, working late. Officer Keir is making a significant error." Torres turned back to Keir, her voice dropping to a harsh whisper. "Uncuff him. Immediately. You were investigating suspicious activity. You are racially profiling a professional in his own building. Uncuff him before this situation deteriorates further." Keir hesitated, his face flushing with embarrassment, but the damage was already done. The body camera had captured the entire interaction. The witness was filming. The evidence was undeniable. He unlocked the handcuffs. David rubbed his wrists, his jaw clenched, radiating palpable anger. Torres stepped forward. "Mr. Richardson, I extend my sincerest apologies. This incident should never have transpired. Would you be inclined to file a formal complaint?" David looked at her, then at Keir, and then at the continuously recording camera. "Yes," he responded, his voice tight with emotion. "I absolutely will, and I will also be initiating a lawsuit. This was not an investigation. This was blatant racial profiling." Building security arrived shortly thereafter. A supervisor named Marcus, who had been employed there for 6 years, immediately recognized David. "David, what on earth is going on?" "I was arrested for entering my own office," David stated flatly. Marcus regarded Keir with palpable disgust. "This is David Richardson. He is one of our regular tenants. He frequents this building late into the evening. Everyone here knows him." Keir remained silent as there was nothing he could say. He had profiled an attorney within his own place of business, arrested him without justification, and been unequivocally disproven by multiple witnesses. Torres radioed dispatch. "Cancel the additional unit. The situation has been resolved, and please flag this incident for supervisory review." Why do certain officers perceive professional achievements in black individuals as suspicious rather than a normal occurrence? Please share your thoughts on this matter. By morning, the account had reached the Oregon State Bar Association. A licensed attorney apprehended in his own office building while attempting to access his own suite. The ensuing outcry was immediate and intense. The Portland Police Department received the official complaint by midday. David Richardson's legal team, as he undoubtedly required representation, consisting of colleagues with whom he had collaborated for many years, initiated a comprehensive civil rights lawsuit within 48 hours. The accusations detailed in the lawsuit were devastating: unlawful stop without reasonable suspicion, false arrest without probable cause, racial profiling in violation of constitutional protections, infliction of emotional distress and reputational damage, failure to adequately train officers on implicit bias, and adherence to reasonable suspicion standards. The body camera footage vividly narrated the entire sequence of events: David identifying himself, David explaining his professional role, David pointing to his name on the door, and Keir proceeding with the arrest regardless. The city's legal representatives reviewed the case and reached a sobering conclusion within a week. The situation was indefensible, the evidence was overwhelming, and the violation was unequivocally clear. Settlement negotiations commenced without delay. The city reached a settlement 8 months later. $2,700,000 was awarded to David Richardson, a sum funded by taxpayers who were compelled to bear the financial burden of one officer's ingrained bias. Officer Jason Keir was terminated 10 weeks subsequent to the incident. The termination letter was unequivocal and absolute. Officer Keir engaged in racial profiling and an unlawful arrest. He detained a licensed attorney entering his own office without probable cause or reasonable suspicion. His actions constituted a violation of departmental policy, state law, and federal civil rights protections. His employment was terminated immediately. Keir's name was subsequently entered into the National Decertification Index. He would never again be permitted to work in law enforcement, neither in Oregon nor anywhere else. He attempted to appeal the decision through the police union, but the union withdrew its support once the Oregon State Bar Association submitted a formal complaint and the body camera footage became publicly accessible. Keir issued a brief statement through his legal counsel. "I made an error in judgment based on incomplete information. I accept responsibility for my actions and offer my apologies to Mr. Richardson." However, it was insufficient. It would never be adequate. The Portland Police Department faced intense scrutiny from civil rights advocacy groups, the Bar Association, and the Department of Justice. The central questions were: how had Keir, with a documented history of 11 prior complaints involving racial bias, remained on active patrol? Why had his supervisors consistently overlooked this pattern of behavior? What specific training was in place to prevent officers from profiling professionals within their own workplaces? Internal Affairs initiated a comprehensive review. The findings revealed a pervasive systemic negligence. Complaints were filed, but not subjected to thorough investigation. Training requirements were ostensibly met on paper, but clearly not internalized by officers. Supervisors were under pressure to resolve cases expediently to meet administrative quotas, thereby neglecting to address underlying systemic issues. The Department of Justice launched a pattern and practice investigation focusing specifically on stops conducted within downtown commercial zones. Within 6 months, a series of reforms were announced: mandatory de-escalation training prior to any solo patrol assignments, real-time review of body camera footage for all detentions in commercial buildings, the establishment of a dedicated civil rights unit to investigate discrimination complaints, and extended probationary periods accompanied by psychological evaluations for officers exhibiting indications of implicit bias. David Richardson emerged as an advocate, although this was not a role he had sought. He testified before the city council. He addressed community forums. He granted interviews to both local and national media outlets. His message remained consistent. "I possessed every conceivable advantage," he stated during one testimony. "I am an attorney. I am fully aware of my rights. I have access to resources. I have colleagues who could assist me, and yet I was still handcuffed in my own building for the offense of being black after business hours." What fate befalls individuals who lack such advantages? What happens to delivery drivers, janitorial staff, security personnel, individuals who work night shifts and are perceived as suspicious by officers trained to view black skin as an inherent threat? He paused, his voice momentarily faltering. "I represent individuals on a daily basis who have been stopped, searched, and arrested without justification. I argue Fourth Amendment violations in court. I actively combat this precise form of abuse, and then I experienced it firsthand within my own office, with my name prominently displayed on the door simply because Officer Keir looked at me and could not envision that I belonged there. The courtroom where he delivered his testimony fell into a profound silence. David subsequently donated a portion of his settlement funds to organizations dedicated to combating police misconduct. He established a legal aid initiative dedicated to assisting individuals lacking financial means in lodging civil rights grievances. Furthermore, he provided instruction to fellow legal practitioners on the proper methods for documenting and contesting unlawful detentions. Nevertheless, his indignation persisted. The lingering awareness of being subjected to such mistreatment within his professional sanctuary. The vivid recollection of being restrained in handcuffs while Sarah captured the scene on video and Marcus offered his corroboration. Yet none of these circumstances held sway, as Officer Keir had already predetermined his guilt, branding him a wrongdoer. Should law enforcement personnel bear personal financial responsibility for instances of racial discrimination? Share your perspectives in the comments section. This incident transcended a mere mistaken stop. It offered a stark glimpse into the insidious nature of prejudice when it intertwines with official authority and unrestricted discretion. Officer Keir failed to perceive an attorney engaged in their professional duties late into the evening. Instead, he saw a black man, presuming his presence indicated illicit activity. His ingrained bias was so profound that he disregarded the signage bearing the attorney's name, the key granting access, the formal attire, and the composed explanation provided. None of these indicators registered because his preconceived notions precluded him from accepting the presence of a black professional in that environment during those hours. This exemplifies the silent and procedural manifestation of systemic racism. There were no overt acts of aggression or derogatory language, only the underlying assumption that black individuals are unwelcome in professional settings after standard working hours. It was the outright refusal to credit explanations that would have been readily accepted from their white counterparts. It was the manipulative use of perceived safety concerns as a pretext for discriminatory profiling. And when this deeply embedded bias is amplified by the authority of a badge, the application of handcuffs, and the power to apprehend, the repercussions extend beyond individual harm. It reinforces the detrimental message that professional achievements, educational attainment, and career success offer no shield against being perceived as a suspect. It unequivocally communicates to black professionals that they must perpetually validate their presence, even within the confines of their own offices. Officer Jason Keir's professional career has concluded. This constitutes accountability. The municipality disbursed $2,700,000. This represents a measure of justice, at least from a fiscal standpoint. However, monetary compensation cannot erase the profound emotional distress. It does not obliterate the profound indignity of being manacled in the presence of colleagues. It fails to restore the sense of security within one's own workplace. The paramount question that now arises is, what transformative actions will follow? Will the department finally accord the 11 complaints the seriousness they deserve before a 12th incident occurs? Will they finally impart to their officers that professional environments encompass black professionals? Will they finally acknowledge that proactive policing cannot be predicated on the presumption of criminality based solely on race and the time of day? Because if we fail to rectify the systemic flaws that led Jason Keir to be accosted in that hallway, if we do not confront the prejudice that shaped his perception of a black attorney as a potential burglar, then we are merely awaiting the next officer, the next victim, the next individual compelled to justify their legitimate presence within their own building. Offer your thoughts in the comments regarding whether this situation warrants national legislation. Any officer found to have arrested an individual within their own place of work, with such an arrest substantiated by documentary evidence, should face immediate decertification. This should be without recourse to appeals or second opportunities. And if you believe that narratives such as this must be brought to light, if you are convinced that accountability is imperative and that genuine reform commences with heightened awareness, then please subscribe, because we are committed to continually exposing these recurring patterns. We will persistently advocate for improvement. We will steadfastly champion the cause of professionals who deserve to work extended hours without being subjected to the indignity of being treated as criminals. This is not merely an isolated incident involving one officer or one attorney. It pertains to all of us and the standards of justice we are prepared to accept.